Demurrage is generally understood as liquidated damages for detention of a vessel at the load or discharge port. It may be contrasted with dispatch, which takes the form of a rebate on the freight which the charterer may be entitled for a prompt turnaround. The issue that arose in this case was about when a shipowner can recover damages in addition to demurrage. Does the demurrage rate fix and limit the recoverability of any loss flowing from the breach of the obligation to load or discharge the vessel within the time allowed, or does it only fix and limit a particular type of loss? This was the question that came before the commercial court in the Eternal Bliss. It's a question that has elicited different answers from judges and commentators over the last 90 years. The debate has centred on whether it suffices for an owner to prove a different type of loss, one other than the loss of use of the vessel as a freight-earning instrument, or whether in order to recover damages in addition to demurrage, the owner must prove a different type of loss and a separate breach of contract. In this case, there was a voyage charter for the carriage of soybeans from Brazil to China. There was a 31-day delay at the discharge port owing to congestion and a lack of storage space for the cargo. Upon discharge, the cargo was said to have been damaged. The receivers arrested the vessel and brought a cargo claim against the owners. The owners later settled that cargo claim at a cost of $1.1 million. The owners issued arbitration proceedings against the charterers, seeking to recover that cost from the charterers. The only breach alleged in the arbitration was the charterers' failure to discharge the vessel within the time allowed. Charterers contended that the claim must fail because there was no independent breach of contract. In the face of that, the parties agreed to refer the question of law to the court under Section 45 of the Arbitration Act. As is explained in more detail in the article that accompanies this video, Mr. Justice Andrew Baker analysed the authorities and academic commentary on this question in great detail, including the judgments of the Court of Appeal in Reader and Arcos, and various dicta in the Swiss Atlantic case. His conclusion that there is no need for the shipowner to establish an independent breach of contract should settle a long-standing debate. His focus is on the purpose of a demurrage clause, which serves to liquidate loss of earnings resulting from delay to the ship, but does not seek to measure or therefore touch any claim for different kinds of loss. In reaching this conclusion, the judge held that the Bondi, a 1991 decision of Mr. Justice Potter, was wrongly decided and should not be followed. He therefore held that on the assumed facts of this case, that a shipowner could recover damages in respect of cargo claim liabilities without needing to prove a separate breach of contract. This is an important decision, which opens a door to claims for damages in addition to demurrage, where an owner has suffered a different type of loss.